payment, when to use what, who, which one by who. Right? At the moment, we've made the parties very simple. It's either plaintiff or defendant. Right? Sanction payments and sanction offers, before we go into all these words and sentences, let's understand the concept again. Again, as I said, you understand the rationale, you will remember which one's by who, made by who, and when and how. Sanction payment and sanction, okay, this is a settlement mechanism. Okay, another mechanism to encourage settlement instead of fighting till the end. So how is it different from just a WP negotiation letter or Coda Bank or Tomlin, etc.? Now, as you see, you see the order number 22. So it's a mechanism, a very fixed and strict mechanism under the rules of High Court or rules of District Court, same number again, where if one side make an offer to the other, let's say the plaintiff makes, let's say the defendant makes an offer, settlement offer under this mechanism to the plaintiff. If the plaintiff does not accept that offer, and in the end, the plaintiff is proven wrong, in quotation marks, or being too greedy in rejecting that offer, then there will be consequences. Now, why have I repeated nagging into you about WP safe as to cost? It's because cost matters. Okay, anything that has to do with settlement offers, sanction offers and payments, what you call Coda Bank letters, all of those are efforts or attempts to settle. And if the other side, the general rationale or principle is that if the offeree, now you've done contract law, so you know who is the offeror, the one making the offer, okay, throwing out the offer, offeror, okay, okay, get that concept right, and no matter whether the plaintiff is making the offer or the defendant making the offer, it's okay. Offeror making the offer, right? Offeree, the one on the receiving end. So, again, the mechanism or the rationale is if the offeror makes an offer, okay, here we're looking at sanction offer or sanction payments. Okay, if the offeror makes any kind of offer and the offeree rejects it, and then later proven that the offeree was too greedy, he fails to do better at the trial than that offer made, then there will be cost implications in a way to punish him for being too greedy. Okay, yes, you may say, okay, how much, okay, if we have a PI claim, well, why can't I reject it? I wouldn't know how much I get in the end. Yes, that's the tough question. Okay, that's the tough question. Would I do better in the end? And that's because that's what we call that Damocles sword, like hanging down there. Well, I better think about it seriously. If I am too greedy and I fail to do better, I'll be punished by cost and interest. Okay. Now, sanction payment, let's go into the wordings a little bit. Sanction payment, an offer by the defendant. I'll explain later why it must be by the defendant. Okay. Sanction payment, an offer by the defendant to settle the whole or part of the monetary claim with the plaintiff. By way of payment into court. Settle down? Yes, we've just sort of started. Okay. An offer by the defendant to settle the whole or part of the monetary claim with the plaintiff. By way of payment into court, made strictly in accordance with Order 22. I'll try to settle down quickly, because this is another favorite exam topic. Okay, sanction offer. We'll go through the definitions first. An offer made other than by way of payment into court, made strictly in accordance with Order 22. Can be an offer by the plaintiff or by the defendant. Mostly, it can be by the plaintiff for monetary and non-monetary claims. If it's by an offer by the defendant, it would be for non-monetary claims only. Now pause there. I'll explain now. Okay, my favorite two classmates at the front, Simon and James. Simon and James, okay. Almost towards the end of our course now. Okay, so Simon and James, my favorite two victims. Simon, who's suing who? Who wants to be plaintiff? Okay, Simon is a plaintiff. Okay, just make it simple, make it a PI claim. Okay, debt claim, even simpler. Okay, debt claim, 5 million. Okay, you're now potentially very rich. Okay, Simon suing James. Who is the one who is the one potentially paying? Is a simple claim? No counterclaim. Plaintiff or defendant going to pay? Defendant is the one potentially paying, right? If there's no counterclaim, Simon is never going to pay money. Accept that first, right? Okay, so sanction payment is payment into court, again, as a stakeholder. Okay, hold住啲錢. Okay, why is it by the defendant? Because the defendant is the one that is supposed to be paying, potentially, right? They're trying to settle. So if they try to arrive at the middle figure, still, no matter what that figure is, the defendant is the one paying. Do you agree? Okay, keep awake, stay awake, because you have to understand the rationale, so it's easier to remember. Defendant is the one potentially paying, no matter how much, if it's a monetary claim. So sanction payment is ever, in terms of monetary, because it has to be payment, right? It's money, dollar and cents. Only ever going to be by James, the defendant. Get that right? So never by the plaintiff. Sanction payments, only by defendant. Payment into court, monetary claim. Okay, because we are saying payment, so it has to be payment, it has to be money. Get that one straight. Okay, now turn to sanction offer. Why can it be by both plaintiff or defendant? Why is it so confusing? Why can't we just stick with defendant and plaintiff? No, because sometimes it's other things other than money. First of all, let's go back to the pure monetary scenario first. Okay, again, our plaintiff and defendant. Now this time, okay, although Simon is claiming James for 5 million. However, as the case progresses onwards, Simon, not only the defendant, the Simon is only saying, also thinking, well, I might not really get 5, although I'm claiming for 5. It's probably an exaggerated figure. Let's say it's not debt. Let's say it's PI, right? The quantum can really fluctuate, right, in the end, right? Depend on how much you can prove as the damage. So although his original claim is 5 million, he thinks a reasonable amount may be 3. Okay, let's say he thinks, well, I'm claiming for 5, but really that's exaggerated. I think 3 is a fair figure. So he can also make an offer. And that's why it's a sanctioned offer, because he's never going to pay, right? It's just a matter of how much he will receive. So he's making a sanctioned offer to James to say, by letter, right? By letter to say, okay, I will accept 3 million. Okay, I'll give you a deadline within which you have to accept my offer, otherwise it will expire. That's the whole mechanism of Order 22. Okay, so pure monetary scenario, you understand why if James makes the offer, it would be a sanction payment, although you call it an offer, it's a sanction payment. Why is it a payment? Why do you pay into court? Why do you think pay into court? To make a genuine offer, why would James make payment into court? If I just talk with, sorry, not Alice, Angela. Sorry, that's a beautiful name. I just keep on forgetting. Okay, Angela. Well, what if if I just say casually to Angela, well, what if I pay you what if I pay you 2 million? Would you accept it? She doesn't know how sincere I am, right? Think about it. If I make a payment into court, you know there is money there. is already cash. It's very attractive because once the plaintiff say, 3 million, that sounds good, and I don't have to waste any more time and deal with this not friend anymore, right? So the money is there. As soon as Simon serves a notice to James saying, okay, I will accept, a few more paperwork, he'll get the cash. And the whole thing will fall away, right? No more case, right? Of course, you have to do some discontinuance or stay or etc. But the case will be concluded. So quite attractive because there is cash in the court ready to go. Sanction offer, if it's pure monetary, he can make the offer. He has to make the offer and say, same-wise, right? The case can be concluded, right? So it's up to James. This time, James is the offeree, although he's the defendant. Okay, same-wise. But because he never have to pay money into court, that's why it can only be an offer by letter to a sort of with sufficient information to comply with Order 22, but it's by letter. If it is for non-monetary settlement, such as title, possession of land, that kind of things, then it can be also defendant's offer on non-monetary stuff. Because only if it's money you can pay into court. Okay, so again, defendant only monetary claim of payment into court. If it's by plaintiff, it's sanction offer. Defendant's sanction offer can only be for non-monetary. Because if it were monetary, the defendant would have used sanction payment. Are we clear now? Are we good? Okay, I've put it as plain as I can. Okay, so now we know by who, why, etc. What kind of claims? These are just the basics. Sanction offer or sanction payment, essentially a settlement offer, can be made at any time after the commencement of the proceedings, treated just like any other settlement offers, as without prejudice, save as to cost. So do you review that to the trial judge? The fact that there has been a sanction offer or sanction payment, do any of the parties review it to the trial judge? Yes or no? No, because it is without prejudice. This bit do not reflect to the judge so that it would not cause prejudice on the merits of your case while it is being heard. Only when we deal with cost matters, then we review it to the judge to deal with cost. Okay, so without prejudice, save as to cost. Must not be communicated to the trial judge. No matter whether it's a sanctioned offer or sanctioned payment, the offeree, the one receiving the offer, has 28 days to accept. Okay, don't confuse this with sanction offer or sanction payment. Okay, whether it's an SO or SP, the nature is still an offer, right? It's just by what method. Okay, SO or SP. Okay, so the one initiating the SO or SP is the offerer. The other side receiving end is the offeree. Okay, the SO or SP should normally remain open for 28 days. If within the 28 days the party, the offerer wants to change it or diminish it, they have to get leave of the court. Okay, so 28 days to accept the offer can be withdrawn or diminished normally after 28 days if not accepted. Okay, if the offeror changed their mind within the 28 days, they need leave of court, as I just said. Okay, because you need to give a reasonable time for the other side to consider your offer. Sanction offers and sanction payments can have serious cost implications. If the offeree, the receiver of the offer, fails to beat the SO or SP. Fails to beat is very simple, meaning you did worse after the trial. You got a worse judgment compared to that sanction offer or sanction payment. Okay, generally on cost and interest. Now, indemnity basis. Now, when we look at cost, which we don't require you to look into a lot of depth at this level, normally the party's cost after trial is tax, what we call tax on a party-to-party basis. Indemnity basis here is a more generous basis. Okay, normally, yes, even though you may have spent, let's say Simon spent $500,000 on cost. Okay, so 500,000. However, even if he wins, and James is supposed to pay his cost, right? Winning party gets the cost, yes? However, not everything can be recovered. Normally what happens is, yes, Simon's solicitors would prepare a bill of costs saying, yes, item this, the solicitor's fees, the disbursements, the counsel fees, paperwork, filing fees, etc., etc. It goes to what we call a taxing master or taxation master. Taxing or taxation master, and who will actually look at it item by item and say how reasonable it is. Most of the time it would end up that it will be sort of discounted after taxation to perhaps 60 to 70%. So normally a winning party, even if he won, he would get about 60 to 70%. That's like a normal party-to-party cost or basis. Indemnity basis, almost all of his costs will be allowed. It would be much more generous. Cost on an indemnity basis. Let's say this time Simon wins. Simon made the offer, but James rejected it. So James failed to do better. So let's say there's implications to James. James had not only have to pay Simon's cost, but on normally a party-party basis, now on an indemnity basis. So a lot heavier. Okay, because it's more generous basis. Okay so far? Okay? Also interest. When we look at interest, we'll look at it a little bit further in further depth later, because not only does James have to pay interest on an enhanced rate, on a higher percentage, basically, okay, than normal. Purpose and rationale is to facilitate and encourage settlement of disputes, so as to avoid long trials and high legal costs and all the disadvantages of litigation that we've talked about. Okay, so to encourage settlement as quickly as possible. Now, from my last group of students, this is well, supposedly I'm supposed to have deleted this so you actually think. Okay, so I'm going to give you a case scenario. Reason or done better. Reason or fail to be, I should. Okay, for every scenario, that's what you have to think about. Is it reason or fail to be? Okay, just to get you on the, we won't give you like this in the exam, okay, but just for you to get the concept. This is what I put up for my last batch of students, because it's quite hard to just keep on talking without something, looking at something. Okay, so pure monetary claim, just like James and Simon, 5 million. Defendant's sanction payment offer of 3.5. Again, the defendant is the offeror, plaintiff the offeree. Now Simon was greedy. Simon rejected the offer. Okay, so what happens if you rejected the offer? The case continues, right? It's not settled, so it continues. After the trial, the judge's decision is that the defendant is liable to the plaintiff for 3 million. Is the final judgment better or worse? For Simon. Who says worse? Who says better? Okay, everyone's okay. So good. So you see, it's worse than Simon. So should Simon have accepted that sanction payment? Yes or no? Yes, right? It's easy to see. So Peter has, not Peter, sorry, Simon. Simon, the plaintiff, has failed to beat. Okay? So failed to beat. And therefore, he will be punished by cost implications. Okay, that is an example of SP, sanction payment. Remember, it's purely monetary by the defendant. Let's put up an example of SO, sanctioned offer. Again, 5 million claim, monetary claim. Not a favorable one now, right, is it? Right. So the plaintiff made an offer, sanctioned offer, of 4 million. So 5 million, probably too much, 4 million. After trial, the judge's decision is that defendant is liable for 4.5 million. Now, who was the offeree again? Offeror again? Plaintiff, right? Plaintiff made the offer, sanction offer on monetary. Plaintiff made the offer, offeror. Defendant, offeree. Defendant rejected the offer. At the trial, defendant is made to be liable 4.5. Offerer, offeree. Now remember, we're not looking at whether offerer's perspective. We're looking at the offeree. Offeree is the one that chooses to accept or decide. Okay, chooses to. So don't think, yes, plaintiff was the one making the offer, so we should look at his perspective. No, we're always looking at the offeree. No matter whether it's plaintiff or defendant, just think about the offeree. Okay. So offeree was, defendant, James. James, the defendant. Did he do better or worse after trial?
Worse.
Who says worse? Okay, you get the hang of it, right? So worse. So again, this time offeree, being defendant, has failed to beat. Okay, so this side. One more. 5 million again. Sanction payment by defendant. 3.5 million. So this time defendant is the offerer, plaintiff is the offeree. Plaintiff rejected the offer. After trial, judge's decision is that defendant is liable for 4 million. Is it better or worse for the offeree? Better. So was the offeree this time? Remember, just think about the offeree. Offeree, the plaintiff, was he correct in rejecting? Right? Was he smart, basically? Was he smart to reject? He wasn't, he has proven to be not too greedy. Right? He was right, he did better after trial. So, plaintiff has, this time, beaten the SP. No cost implications due to the SP. Whereas, if we have, if we have failed to beat, every time the offeree failed to beat the SO or SP, there will be cost implications. Okay, so we get the hang of it now, totally clear. Okay, sanction payment must be made on Form 23. It must state the amount of payment. Remember, this is a very strict SP has more formalities than SO because there is payment into court. So there are more forms to fill in and in the prescribed format. Okay, must be made on form number 23. It must state the amount of payment, whether that payment relates to the whole claim or part of the claim, or to any particular issues. Well, what if it, let me finish it. Whether it takes into account any counterclaim or right of set off. So you must be very clear if there are counterclaims, if there are set off in your claims, against your claims. As to the second part, I think by now you know you can, just like admission, it can be whole claim or part of the claim. What do you mean by any issues? The one that just now come to the top of my head would be, well, what if one party is staying on as a tenant after the lease expired? James has stayed on in the premises, refusing to leave. So now they're trying to settle. So perhaps James, let's say, wants to say, oh, I want to stay for another 2 months, so I will pay. Part of that money is for the mean profit, what we call the mean profit, or the rent, so to speak, de facto rent, while I stay for another 2 months. So it can be that as well. Okay, so that's why I can say, for example, that's the only example I can think of when I say to any issues. Also, you have to specify whether it has taken into account any interim payment, if any has been made, or other monies paid into court other than as security for cost. Must also deal with the matter of interest or state that the payment is inclusive of interest or not. Okay, so that was the formalities of SP. Okay, must be in prescribed form. By the way, most of these prescribed forms, including your writ, etc., they are all in appendices behind or at the end, towards the end of the rules of High Court or rules of District Court. Let's turn to sanction offer. The formalities is less because it is just normally in the form of a letter. However, it must meet the requirements under Order 22, Rule 5, which predominantly talks about what kind of content or what kind of issues you have to specify. Again, it must state that the offer, whether the offer relates to the whole or part of the claim, or to a particular issue, and if so, which part. Again, whether it takes into account of any counterclaim or right of set off. Deals with interest, whether the offer is inclusive or exclusive of interest. It must also state, right, that it would be open for 28 days, but if made at least, okay, start again. If the sanction offer is made at least 28 days before commencement of trial, that after the expiry of 28 days from that date, the offeree may only accept if the parties agree on the liability for cost, or if the court grants leave to accept it, basically because it runs too close to the trial. Okay. Okay, you have a sample of a sanction offer letter on page 126 in your manual. Okay, you might as well look at your copy, otherwise it's pretty small here. Notice that it's dated, it states that it is pursuant to Order 22, Sanction Offer, and that it's without prejudice, safe as to cost. It talks about it being, again, Order 22, proposed full and final settlement of the whole claim, about the amount, Remember, this is by the plaintiff, right? If it's monetary. Your client shall pay, you can see, right? Your client shall pay our clients. So we are the plaintiff. Okay, the amount, interest, any other matters like here is a return of working tools and modes, probably concerning a factory or production. See how it deals with interest? Towards the bottom, takes into account of all the following counterclaim or set off, and state what we just looked at, right? After the expiration of 28 days from the date of this sanction offer, your client can only accept this if both parties agree on the liability for costs or the courts grant leave to accept it. Okay, so much less formal. Whereas if you look at this form, okay, on a prescribed format, take notice that the defendant is just on the next page. Defendant James has paid 3.5 million into court in settlement of the whole of the claim, let's say. Right? Gives further details if there are further details it relates to. Okay. Notice the word that already paid. Already paid into court. This is a notice that James gives to Simon, the plaintiff, after the payment has been paid into court. Okay. So by the time the notice is served, the money is already in court. Okay, that's timetabling questionnaire. We have to look at that. A quick table of summary. Okay, a quick table of summary. It should be the same for your PowerPoint. Looking at the left-hand side, sanction payments. By defendant only, so it's a quick rerun. Defendant only for monetary claims only, for the whole or part of the claim. Okay, whereas sanction offer by plaintiff for monetary or non-monetary claims can also be by defendant for non-monetary claims. Both can be made at any time after commencement of proceedings. Sanction payments on the left-hand side, sanction payments can only be made by physically depositing money into court, including interest from date of writ up to the date of judgment. Sanction offers are made in the form of a letter. No special form, but you must state all the required information. One down. Sanction payments, after the payment is deposited into court, the money is deposited into court, the defendant would serve the notice of sanction payment, the form we saw, form number 23. Defendant then files certificate of service of notice. Notice of what? Notice of that sanction payment. Right? So first, notice is served. Second, file into court to say, yes, I've served on the plaintiff. Offer remains open for 28 days. Same here, offer remains open for 28 days. So, after that, what? If it is accepted, if the sanction payment is accepted by it can only be plaintiff, right? If the plaintiff accepts the sanction payment, the plaintiff, being the offeree, right, has to do something to say to the other side, yes, I will accept. How do they do it? Before they get the money, they must confirm the acceptance, right? They can't get the money and then run. So the plaintiff files into court and serves on the defendant the notice of acceptance of the SP. And that is Form 24, pursuant to Order 22, Rule 15. Sanction payment deemed to have been accepted when the notice of the acceptance is served on the defendant. No turning back. Again, it's binding. The decision is binding. After the plaintiff files into court and serves on the of that notice of acceptance, the plaintiff then files into court and serves on the defendant also the request for payment, meaning, okay, I confirm, I accept, now pay me. Okay, give me my money. Guess what? After 23, 24, now 25, form number 25. And after that, the plaintiff can get his money, obtains the payment out of the sum in court pursuant to Order 22, Rule 17. Okay, normally that would be the sum and interest and legal costs. From start of the proceedings to date of acceptance, the action is stayed. On the sanction offer side, can be accepted by D or P, right? Defendant or plaintiff, depending who's offeree, who's offeror. The plaintiff or the defendant files in the court and serves on the defendant the notice of acceptance, also form number 24, pursuant to Order 22, Rule 16. Okay, it can also be D, right? As I said, depending on who. It's just the accepting party filing into court and serving on the other, on the offeror. Sorry, it's a jumble. Okay, so far, right? No questions. If rejected, whether it's SP or SO, the case proceeds to full trial. No disclosure of the fact that an SO or SP has been made. You just go to trial as normal. The SO or SP would have been, if you don't file a notice of acceptance, it's deemed that you haven't accepted it. So it's sort of it automatically is rejected, right? After the expiration of 28 days. Consequences of rejecting. Now we sort of look at what do we mean by winning or beaten, right? Beaten or failed to beat, right? Whether you've done better or worse. Now, a winning plaintiff is generally entitled to the cost of the proceedings, up to the date on which the notice of acceptance was served on the offerer unless otherwise ordered by the court. Okay, under Order 22, right, if you actually accept that SO or SP. Where a party rejected an SO or SP but fails to beat the sanction offer or sanction payment after trial, the court may, under Order 22, Rules 23 and 24, impose the following consequences. Enhanced interest rate on judgment award or deprive the plaintiff of interest on the award. Award costs on an indemnity basis. Impose generous interest on costs. Now, one by one. When we say enhanced interest, now currently, let's say the current judgment rate that is fixed by the judiciary from time to time is 8%. It hasn't changed for a long time. So normally you get 8% from judgment date until payment. Okay, that's the general rule. When we have any kind of enhanced interest, it means higher, right? Enhanced, higher. It can be enhanced up to 10%, an additional 10%. I have it on the next slide anyway. Okay, so it can be enhanced up to another 10%. So what's the maximum? 8 plus 10? 18. That's almost 20%, 1/5. Right? That is a lot of money. So you think, okay, so I don't care. I don't want to accept offer. I may do better after trial. I don't want to accept it. I don't care how much it is. Well, think again. Another thing is, let's say Simon, the plaintiff, has rejected the sanction payment. Now, at the end of the day, he got 3.5 million, let's say. Okay, 3.5 million. The original offer is 4, so he has failed to beat. Okay, let's make it simple. He's failed to beat the sanction payment. Now, normally the winning party gets cost, right? James should pay. Now, guess what? This time, because he's too greedy, there's a period he won't be paid his costs. Guess what? Guess from when? From the last day, from the time he could have accepted the sanction payment until the end of the trial, which is normally the most expensive, right? Because you need counsel, That's where most of the work is done, right? Close to the trial. Right? So not only would he not get his, he won't get his legal costs, basically. From normally, well, if you want an exact date, it is from the last day he could have accepted the sanction payment. Remember, that's a 28 days window, 28 days, right? So the 28th day is what I'm saying. Okay, until the end. Because what's the rationale? Simon, you could have accepted that sanction payment. The whole thing would have stopped there and then. Because you haven't looked at the extra cost. Okay, and you failed to do better. So you were too greedy. That's the rationale. We don't actually say you have been too greedy, right? But we just say you have failed to beat the sanction payment. Okay, so but the concept is that. What if it's the other way around? What if the defendant has been the one too greedy and reject the sanction offer from plaintiff to defendant? Well, why would I care? Because I would have had to pay costs anyway, right? So I might as well reject the offer. Because we said if he is greedy, he won't be paid his cost for that period. Well, guess what? He has to pay more cost. Higher interest as well on what the award is. Let's say the final award, that liability was for the judgment award is 4 million again. So first of all, he would have had to pay costs anyway, right? But he has to pay costs on what we call an indemnity basis, which is much more. So instead of 60 odd percentage of the bill, perhaps he would really have been paying 90%, right? Just a rough figure, right? Because indemnity is, unless it's very unreasonable, it'll be allowed. That's the basis. So he'll be paying on a much higher basis or more generous basis of cost. On that $4 million award, there would also be judgment rate. Apart from the 8% judgment rate, it can be increased up to another 10%. Quite harsh, right? So don't think that just because you have to pay costs anyway, so you might as well reject it. So also very harsh. Okay, that's what I mean by indemnity basis. More generous rate on interest. That's exactly the enhanced interest rate. So 8%. Well, normally at the cases that I normally see or saw, they may not put up the full 10%, but 8 plus at least another 6. That's pretty typical for Order 22. Don't quote me on that. Sometimes the judge can decide on more because the max they can increase is up to 10%. Okay, so again, this is the scenario for James, the defendant. Defendant failing to beat the plaintiff's sanction offer. That's what I was saying. Interest on the whole or part of the judgment at a rate not exceeding 10% above the judgment rate. Judgment rate being at the moment 8%. So 8% plus, instead of 8%, maybe 14%, maybe 18%. Okay, up to 10% more than 8%. For some or all of the period after the latest date on which the defendant could have accepted, again, almost towards the end of the expiration of the 28 days, until the end of the trial. Now, why can it be sometimes for some or all? There may be some arguments about some internal or inter parte communications, etc. But it can be from the last day that the offer could have been accepted until the very end. Costs on indemnity basis incurred after the latest date. Interest on those costs as well. At a rate not exceeding 10% above judgment rate. So not only on the 4 million, also on the interest costs. Now, civil litigation, because it runs for so long, is not uncommon for costs, a typical civil case cost to be up to $1 million. Very easy, actually. If you go across about 3 years, okay, it may run from $500,000 to $1 million to beyond, depending, and I'm talking about very economical rate of solicitors and counsel fees. If you use senior counsel, one interlocutory hearing you can spend 300,000 just for the counsel fee, for the senior counsel. Okay. Okay, so any questions on that? Okay, similar stuff, I've talked about it. Unless you have anything you don't understand, that's exactly the same. Okay, just on the plaintiff side. Okay, one point to note probably is there, disallow all or part of any prejudgment interest. So 4 million, plaintiff rejected offer, plaintiff failed to do better. So prejudgment is from the time the payment should have been due. Let's say the, how should I say, prejudgment, right? As the word prejudgment, before judgment. From what time until the judgment? Let's say it's a debt. James should have paid Simon 6 months ago. So after 6 months, Simon commenced the writ and Sue start claim. It might have taken another year, right, for the case to conclude if there's no order 14, etc. Right? So altogether, from the time the payment of the repayment of the loan, 18 months has passed, right, until the judgment. From the time the payment is due until the judgment time, the judgment is given, 18 months, that would be the prejudgment period, or the prejudgment interest period. Okay? And then there will be post-judgment from the time of judgment until paid. Indemnity basis, yeah, we've talked about that. Enhanced interest rate, we've talked about that. And because I try to be nice, I give you another table. Okay, so this is just on exactly what we've talked about. Okay, just another table. I've explained the details beforehand. Now, the last table we had was, what if we looked at how it's made, what if it's accepted, the action will be stayed, remember, after all the formalities. If it's rejected, then the case proceeds to trial. When the judge considers costs after the trial, these are the implications, okay? Just the summary of what the few slides that we went through. If it's rejected, but the offeree has done better or beaten the sanction payment, there's no impact because the plaintiff has been proven to be right in rejecting. Okay, so no implications, no punishment, no cost implications. Get it? However, if the judgment awarded is less than or equal to, because if it's equal to, why didn't you end it and just get the money? Right? So if it's equal to or less than or worse than the SP, the judge will then be told of the sanction payment then when dealing with cost. Plaintiff disallowed prejudgment interest on sum awarded from the date SP could have been accepted until judgment. Plaintiff also to pay defendant's legal costs on indemnity basis. Interest on defendant's costs at a rate not exceeding 10% above judgment rate was missing. Okay, plaintiff's own legal costs, of course, have to be borne by himself. Okay, so not only can he not get his legal costs paid, he has to pay the defendant's legal costs during that period. Okay, after the time the sanction payment could have been accepted. Flipping the coin to the other side. Okay, again, for SO, if the plaintiff or defendant, if the offeree has beaten the sanction offer, no impact and no cost implications. If failing to beat the SO, again, the judge will only be told of the SO when dealing with costs, after the main judgment is given. Defendant is to pay enhanced interest rate on judgment award, so 10% above the 8% judgment rate. Again, from the date the sanction offer could have been accepted until judgment. Defendant have to pay the plaintiff's legal costs on indemnity basis. right? You understand, right? This enhanced interest is on the judgment award, the $4 million liability and quantum. Here is about cost. Okay, cost on an indemnity basis, so it's on a wider basis, large amount, at a high interest rate. Okay, so in relation to cost, a wider base, so a high amount plus higher rate, okay, because of the enhanced interest rate. And defendant, of course, have to take care of his own legal cost. Well, you will say, well, sometimes it may not be fair. Should we, should we adhere to it so strictly, right? Those cost implications, right? Cost and interest implications. Well, the court is very much likely to impose the cost implications that we looked at, unless it considers it unjust to do so. Now, one overarching principle is that cost is always at the discretion of the court. So in other words, the court can almost do anything with cost. However, because they want to be consistent, they're more likely than not to adhere to those cost implications under Order 22 unless there are exceptional circumstances. In making the cost orders, the court will consider the terms of the sanction offer or payment, the stage at which that SO or SP was made. Was it very late? Was it very early? Etc. The information available to the parties when that SO or SP was made, and the conduct of the parties generally. Now, why would we talk about timing and information, etc.? Well, what if it's a personal injuries claim between Simon and James? It's at a very early stage. What if the victim or the plaintiff's injuries have not stabilized? Perhaps you don't know how much to claim yet, right? It's very unclear how much the claim would be or whether it's going to still continue to be higher, right? It may be hard to assess the amount which you should accept, right? Maybe very early at the stage. What if there is material non-disclosure by the other party and the evidence later reveals more, right? So there are still factors that the court can consider and the parties can argue. Okay. Apart from that, parties, whether the plaintiff or the defendant, are generally free to make offers to settle their case in whatever way they like. However, if you want to, in a way, threaten or pressure the other side with those cost implications, you should make those offers or payments in accordance with Order 22, because it's much less likely for the court to deviate from those cost implications, right? If you make it in accordance with Order 22, the consequential cost implications are likely to be carried out. As I said, cost orders are always at the discretion of the court, may still take into account any written offer expressed to be without prejudice, save as to cost. However, the court may not take into account whether the party making such an offer could have protected his or her position as to cost by means of a sanction payment or sanction offer. The last point there just simply means that the court won't penalize you for not making an offer or payment. Okay, although any offers made would be taken into consideration. However, the court won't particularly rule against you on cost order just because there is no SO or SP made. Okay. Now, I think the next activity is asking us to draft a letter or letters. Now, to give you an idea, Coderbank offer. Now, why? Well, one of the question is about, or one of the things that we asked to consider is, why do we still need different kinds of offer letter? Why don't we just go straight to SP and SA? Right? There are different ways. You can just write a letter, even if it's not SO, even if it's not Coderbank offer letter. Right? Coderbank letters nowadays are often used to for negotiation before the action is even commenced. Okay? But anyhow, what I'd like you to do is, instead of reading out, I don't have a, other than what's in the course manual, I don't have a template for this scenario. Okay, this scenario that we're given, the landlord and tenant. So I guess you can have, the next session is going to be quite light, so you can have 5-10 minutes discussion about the main points you would put into, just in bullet points, right? If you were to draft a letter of offer, and when you're talking about, I want you to look at a few things. Should there be a sanction offer or sanction payment? If there is one, what would you think would be the content? Okay, just in bullet points, so we can just have a general volunteer of discussion. Okay, I think that's all I want you to do, because it's otherwise quite hard for you to draft a letter, right, in class. That's also only discussion. Okay, so why don't, if it's only about an hour, so why don't you spend some time doing some discussion? I'll give you around 10 minutes. Is that okay? Just to think about, well, is this a scenario you would make an SO or SP? Right? Remember, the plaintiff can only make an SO. If there's a non-monetary claim, it can also be an SO. So, and what kind of contents? Imagine both sides, whether you're the tenant or the landlord. Okay? You can feel free to discuss.
Landlord failing to disclose to the tenant is already taking place and the tenant refused to pay rent.
Or would you prefer me just to designate you as the tenant and landlord so you can concentrate on one side? Any preference? No? Okay, just go ahead then.
To apply for an intern.
And the question is, should there be SO or SPA? How much is
For that?
that? Yeah.
Well, I mean, I think it's pretty reasonable to say that landlord should know that maintenance work is going on. I think it's pretty reasonable because you're the landlord. You should know that shit's going on. Right, so, and he's also wealthy. So,
So you mean the tenant shouldn't pay? She didn't pay for the rents.
that's the thing. I'm kind of wondering how this will go down. What do you think?
The tenants can't run her business, so she didn't have money. It's reasonable for her to not pay the rent.
So presumably she should pay your legal fees.
The tenant deserves to have the cost back, I think.
Because the landlords are the one who's the plaintiff in this situation, which is really messed up, but you know how it is.
So the tenant should do the sanction payment, but she can't pay.
Yeah, she can't pay, so it wouldn't be just to make her pay. She can't even pay her rent. She can't even pay her rent. I mean, she can pay legal fees, okay, but you can't even pay your rent. It's probably not just, right, to try and get her to pay. She doesn't have the money for that. Especially since her business was affected by the landlords. I don't want to necessarily say negligence or some shit, but like he didn't tell her about the maintenance work, and he should know, or they should know. I don't know if they're he or she. They should know, right? I'm just gonna